So good morning, everybody. Thank you very much for joining me, and thanks very much to people who are listening for joining us. With me today, my name is Sarah Auld. I am a lawyer at Findlay Lawyers in Hamilton, Ontario. Before becoming a lawyer, my background was kinesiology, so it's kind of an odd path that I went down to become a lawyer, but here we are. With me today, I have Lesha Dyke, who is an occupational therapist. She graduated from McMaster, my alma mater as well, in 1989 as an occupational therapist, and she went into private practice in 1998, having worked in different facets of occupational therapy. She is the current president of and clinical director of Lesha Dyke Occupational Therapy Services Incorporated, and that business offers complete occupational therapy services to motor vehicle collision survivors, as well as the aging population, which is becoming more and more of a thing these days. Lesha is the past three-term president of the College of Occupational Therapists. Those terms ended in 2014, which I'm sure freed up some of her time a little bit to return to the practice. Also with me today, I have Brent Piper, who is a chartered accountant since 1985. Brent is a partner at Durward Jones Barkwell here in Hamilton. Also, Brent has been providing litigation support in his capacity as a chartered accountant since 2001, so quite a long period of time, providing calculations of economic loss and future cost of care and other forms of litigation support that are needed when people have been injured or had losses. So thank you very much. Both Brent and Lesha have been called as experts at trial to give opinion evidence, which is quite a privilege because that's generally not allowed. And they've been qualified as expert witnesses in their fields. So thank you very much for joining me.
Thank you.
Thank you.
So the topic we're going to be discussing today comes from a recent decision in a case called McNamee versus Oikle, or so McNamee and Oikle. It was a case that went through a full-blown trial where they called evidence. There was a couple that had been injured, and they called evidence in terms of both need for future care as well as economic losses in the future for the husbands. And at the end of the trial, so they've gone through several days or weeks of trial. At the end of the trial, the defense brought a motion with respect to the jury questions and to have the judge decide whether or not questions could be put to the jury about these heads of the images, so future care costs as well as economic losses going into the future. And the defense position was that there was no evidence that had been brought at trial to support these claims, and so it was improper for those questions to go to the jury. In what looks to be kind of a strange decision, and we'll see if there's an appeal later, the judge agreed with the defense that the questions should not go to the jury on any of those categories because there had been no evidence to support them. So pretty tough on the injured parties to go through an entire trial. You think you've called the evidence, and then as it turns out, the judge is not satisfied that there's been any evidence that you can rely on and doesn't allow your questions to go to the jury. So that's a big problem. So the witnesses that were called in the case included somebody like Brent, so an actuary, to give some evidence on economic loss as well as future cost of care. It doesn't look like the costs of care were actually calculated, but she tried to give some tools to the jury to let them do that on their own. It was determined that the problem with her report as far as the economic losses were the assumptions that were given to her by the lawyer. So we'll talk a little bit more about assumptions when we're talking with you, Brent. And then there were some various medical rehabilitation recommendations that had been made, but they were very general. And I think, Lesha, you're going to cover off some of that. So, a couple of people had, seen the injured couple and had said, well, yes, I think they will need some treatment in the future, but really didn't quantify that. So based on, that evidence and who was called, the judge didn't allow the questions. Maybe what I'll do is just ask some questions to both of you so you can talk to us about, some sort of things that go into this and kind of best practices. So Lesha, maybe you can help us with what a future cost of care report, what is that?
So it's a report that does a bit of a historical background about what happened, client's injury that could cause a client's injury, talks a little bit about what their life was like before the accident or injury, and then sets out a framework of all of the goods and services that are going to be required for the client's life to look as close as possible to as it did prior to the accident or injury.
Okay. And who is ideally going to prepare this kind of report?
That's a very good question. There are people who have the Certified Life Care Planner designation. This is a course of study that you can take in a private learning institution. It sets a bunch of methodology to approach these questions that are required to answer in the future cost of care report. There's also occupational therapists that are doing these reports because they have the background to look at the whole functional aspect of somebody's life, and they are also regulated healthcare professionals. It's important to know that there are some bodies, vocational assessors and case managers, that have a volunteer, a regulatory body, but they're not a regulatory body like doctors or occupational therapists or nurses. So I think that one of the things that you may want to look at is the quality of the assessment is governed and mandated by a regulatory body, and that's a little bit of a higher standard, I think. However, I know of a lot of lawyers that want to have the Certified Life Care Planner designation because of the methodology that is being used in order to come out with the opinions at the end.
And it's fair to say a lot of occupational therapists also go ahead and get that training. Is that
Absolutely.
right? Okay. So maybe you can just tell us a little bit about the process that you go through when you're preparing one of these reports.
Sure. I think the first thing that you have to do is to have a very good idea of what a person's life looked before the accident, and not just from them, from several sources. And so you're going to be using a previous reports, you're going to be assessing the client themselves. You want to have corrections from somebody else to say that their life looked the way that it did. They were doing these things. They were participating in this way. They had these interests. They were doing these sports. So it's not just taken from one source. You want to have a really good idea of the physical, cognitive, and emotional sequelae of that accident or injury at present, but more so to get some opinion about what this may look like in the future. And these should be based on professional medical opinions. And you may need to make a few phone calls to their treating practitioners to try to get that information if it is not in a medical legal, set out in a medical legal report already.
Most lawyers encourage you to reach out to the healthcare providers.
They should. If they don't, they should. And this really does come down to the question that you have at the end, is that has to be the basis of the recommendations for the future. That they need to be based on some sort of medical opinion or psychological opinion going forward.
The more the merrier, really, as far as information that informs your opinion.
Absolutely. And to make, especially things like future need for surgery, it's really not good enough for an occupational therapist who does not have the scope of practice to be allowed to prognosticate, to say, well, they might need, surgery in the future. That's not within our scope of practice. We really need to be able to go to an MD, preferably the orthopedic surgeon who would be doing the surgery, to say, might this be something that would have to be done in the future? And from that, the occupational therapist can transpose the needs that are going to be required in the future.
Great.
And then basically the recommendations need to be, reasonable and necessary that you're making. You need to be able to pair your recommendations with what the client's life looked like before. So if the client didn't undertake a thorough spring cleaning and you have no proof that happens, it really shouldn't rely, in your recommendations. Likewise, some of the therapies that have been, or swimming, as a recreation, wasn't doing that actively before. That really shouldn't lie in those recommendations. And even so, if they are part of the recommendations, they should be reasonable. It is reasonable for somebody to join a local recreation center or a local YMCA to do their swimming. I do that. A lot of people I know in my circle do that. And not very many people I know have a swim spa, right? Who've got that done, who've got that installed. So those things have to be reasonable.
Great, thank you. So what would you say are the kind of key points to a quality report?
So I think that, a quality report should be realistic. It should be in context. But I think that the most important thing, and this is really what comes to the decision, is the report needs to be able to, for the untrained person, and I always tell my students that the report should read as well forwards as it does backwards, meaning that the points should be connected, the dots should be connected for the untrained medical person. And so at the end that they can say, oh, I see that they need physical therapy because of this issue, and this issue was caused by this aspect of the accident and the ongoing impairment. And so it really needs to be in context. You cannot make any recommendations that are general. That's just not good. You need to say that the client needs ongoing physical therapy in order to address ongoing issues with strength and balance due to nerve damage in the lower legs because of the back injury in the accident. That's really how it needs to read.
I agree with that for sure. And that goes to part of what you've mentioned is some of the things that concern us for sure. So the onus of proof for injured people is always on the person who's making the claim. So whoever points the finger and says, you did this to me and I now need, XYZ, then the two things that we have to prove legally is that the need is in fact there. So talking about the things that you're relying on, in terms of there needs to be medical and other evidence, and that is in fact linked causally to the event that we're, fighting over in the courtroom. So that's very helpful. So is there anything, when you're preparing these reports, is there things that you choose not to include in your reports? Like, what can you tell us about that?
So things that I wouldn't choose to put in a report is something that I thought would be frivolous. I don't think that we need to put in something that would be obvious that they would be using anyway. Those are the kinds of things that are not helpful for people to look at the quality of the report. If you start putting a bunch of frivolous recommendations in, it will color and the quality of your report will be judged. So, I mean, I think that things like, ongoing hot packs or some things that are nice to have, but maybe not, really substantiated in the whole, global opinion of what this client will need in the future. Those are the kinds of things that I feel that are going to affect the quality of the report. And also, like I mentioned about the swim spa or, first class tickets, to fly with an attendant. I mean, those are some of the things that are really, I've seen in the past that are really, again, difficult to substantiate. Gone are the days when it was expected that you would literally put everything that you could possibly think and the kitchen sink into a report. I think now that people want to be realistic and respectful of the court and of the opinions that are required. And also, this goes to the question of substantiation is that you're not going to get any doctor or so on to say, well, you have to install a swim spa in somebody's home because the make or break in their health in the future.
Okay, great. Yeah, thank you. That's helpful. So I think you've sort of already covered this off, but can you just kind of help us with what the ultimate goal of your reports are?
I think the ultimate goal is to give the court a document that is going to understand sort of the journey of what the client's life looked like before, what changes have happened in the client's life from the physical, cognitive, and emotional standpoint, and what treatments they've undertaken to try to mitigate those losses. And with all the treatments that have happened, what losses still, impairments still remain, and how a roadmap, if you will, of how one would plan to deal with these impairments in the future in order to ensure that the client's life is being lived to as a full, in the fullness as possible of their life before the accident.
Great. Okay. So now, Brent, we're going to turn to you and put you in the hot seat. So maybe you can tell me about your role once somebody like Lesha has prepared a report and that report is available, then what's your role once that's ready?
Our role would be to take the report, which shows all the devices and aids or therapies and services that a person is likely to need now over their lifetime, and to try to cost that out, to come up with a number that says, okay, in order to be able to pay for those things over this person's lifetime, they need X amount of money. So our job is, certainly as accountants and economists, is not necessarily to be questioning anything in the professional report that someone like Leslie has put together, but rather to take that and now try to cost it out.
Okay. And
typically speaking, that report will probably have a lengthy narrative, and then quite often a chart summary showing all the costs, all the items that they need. For example, they need physiotherapy. It costs X amount per hour. They need X number of hours, so they need this much per week or per month or per year. And they'll need that over their lifetime for the next 5 years, something like that. And they'll have a chart that shows that. And so our job is to take that and calculate how much will it cost to have that service.
Okay. And when you get the report, are there already costs associated with that? This is maybe something that you want to respond to as well, Lesha, but do you come up with the numbers to figure out how much this is going to cost, or is that provided to you?
That is provided to us. That'll be in the report, and it'll show how much they need, how often they need it, and then we cost it out from there. So, but that would be in Leslie's report as to how much that costs.
And Lesha, how do you come up with those costs?
There are guides through. Sure. So there's the various methods. You can get them directly from the treatment provider. You can go to provincial professional associations and find out what their cost ranges are. I believe all of the professional associations have an hourly range for their services. You can also, with the internet, there's a lot of information now about costs for non-professional services. For example, nursing care or PSW care or housekeeping and home maintenance. And so I think the most important thing is that you ensure that you find what the ranges are in the community where the client lives, because it can vastly differ from downtown Toronto to a home in Simcoe, Ontario, what those costs would be.
Sure. Yeah, that's a good observation for sure. So turning back to you, Brent, can you maybe tell us a little bit about your process, like what kinds of things are going into your report?
Sure. We'll take the report from somebody like Leslia and review through it.
I think we're having a little problem.
We don't necessarily follow this. But we will recheck their calculations, and if they've done an hourly rate for X number of hours for so many months of the year, generally speaking, we find those calculations are correct, but occasionally we find an error, and then we have to say rate was different, or was it a typo? So we'll often call the professional who wrote the report and ask them just how that calculation should be corrected, so that we have the right number. Then we will create a chart in using a program like Excel, and take out all those costs each year in today's dollars. And what we'll do is determine the present value of those costs. And present value basically means how much should I give a person today that they can then take that money and invest it and earn some interest income to be able to have enough money to pay all those costs over the rest of their lifetime. And then at the end of it, there's no money left in the pool. They've spent it all. But they should have enough to be able to afford those services. And that takes into consideration the fact that the costs will go up with inflation. And it also takes into account that they will be able to invest that pool of money and earn some interest income. So that's the present value calculation we do. And we will do that calculation out for each item or each service. So if they say they need physiotherapy, we'll determine the present value for the physiotherapy. They need aqua fitness, we'll determine the present value for the aqua fitness. And we'll do it for each item. So judge or jury is reviewing the reports and they go, yeah, okay, we think they do need physiotherapy. They do need this, but they don't need this service. We don't think that should be provided. They can readily identify that cost and take it out of the total. We just gave a total cost. Leslie's report would cost $510,000. Then the jury can't deal with that. But if we give it to you by each item, they can then determine this amount, this amount, this amount, and make some decisions. So hopefully avoiding what seems to have happened in that case, where the jury didn't have the ability to modify the number and come up to what would be a reasonable amount.
Well, it sounds like they actually didn't even have a number, and the actuary just gave them a suggestion of like, well, if you guys want to figure this out, here's how you would do it.
Yeah.
So.
Yeah. And the one thing we will generally give as well is a report of $1,000 a year from today, from the date of the trial, out to the person's life expectancy with a cumulative total to say the present value to every age or for every year will be this much. Because a lot of times a report may say this person needs physiotherapy for 10 years, or they need chiropractic treatment for 5 years. And so we'll cost that out. But the jury may say, well, we think maybe we'll just pay for that for 3 years. So now how can they do that? Well, using our schedule of $1,000 per year with a cumulative, they can easily, and we show examples in our report how to use that, but they can then take the one number out that we put in and recalculate relatively easily the amount to a different age group. A lot of times something like home maintenance will be taken out to life expectancy, but they may say, well, we'll take it to age 70 instead. So you can readily do that adjustment with our reports.
So they can take the chart and essentially just run their finger down to age 70 and go, okay, so now
take out the one.
Yeah.
Correct, yes.
It's a helpful tool, I would think, for a decision maker. So one of the things that came up in this this case where the judge made the decision not to send the questions to the jury was that the accountant or the person doing the valuation of this person's future economic loss had relied on some assumptions, and the assumptions are given by the lawyers. So what can you tell me about how you handle assumptions when they're given to you? You can just define what that means, and then you can talk about how you kind of look at those.
Okay, maybe I'll go first. Typically, the assumptions, and we don't generally get a lot of assumptions given to us on this type of thing, other than do you want to take certain things like heavy outdoor spring and fall cleaning to life expectancy, or do you want to cut it off earlier? They may have some assumptions as to that. But typically, we are just taking the report that Leslie has done and costing it out. The assumptions are all deep into hers. Occasionally, we will see something in the report that doesn't necessarily agree to other information we have, especially if we're doing an economic loss report. We may know something about what this person was doing for the rest of their life, and it doesn't necessarily agree. We will typically go back to the lawyer then and go, this doesn't seem to tie into what you've got going on the economic loss. How do you want to handle that? Because you don't want to have two different reports saying two different things. So we try to be mindful to that kind of thing, but typically the assumptions come probably more down into Lesia's reports than ours.
Okay. So just to clarify your process, you wouldn't necessarily, like in a case where you're being asked to calculate future costs and you're also being asked maybe to calculate an economic loss for employment losses, you don't only have those reports, you have access to other things. What kinds of information do you need in order to prepare those kinds of reports? Or what do you typically ask for?
For an economic loss report? Or
if you're asked to calculate a future care report, do you ask to see other medical information or transcripts or, other information?
Yeah, so typically if all we're going to be doing is a future care cost report, then we should only really need Lesia's report. Generally speaking, they very, very well lay out all the medical aspects and reports, and they summarize them all up, and they talk about all the needs, and that's really their job to determine the cost needed based on all that. So we don't then go back through and try to read doctors' reports. We will review through Lesia's reports to see what it says, and then see, yeah, it flows through the charts that they've put together. But we don't necessarily other thing. If we're doing an economic loss report, somebody's had an accident, they can't work any longer, we probably have a lot of other information about their personal taxes, corporate taxes, medical information, and things like that. And so at that point in time, we may very well have read other medical reports that might suggest something different, or we may have them, they can't return to work, and yet Leslie's report may be saying, well, they need assistance to get back into the workforce. But the assumption is they can't go back to work. So why would we now pay for this if they can't go back to work? So that kind of thing.
Okay, great. And then I guess, what is the ultimate goal of you preparing a report? I guess you've kind of covered that off, but maybe you can just give us a little recap.
For our ultimate goal is to determine the amount of money that the person would require to pay for all of the services and devices and aids that the person will need over their lifetime because of the accident, as recommended in the professional's report. And that's our job, is to give you that information and to give it to you in a manner that you can then use it to negotiate with or give the jury to, so that they can determine the various costs and what to do with them should they want to modify things.
Okay, great. So I'm just going to cover off a little bit of the legal test in terms of how this gets treated. So probably many people who will be watching this are sort of familiar with the whole, what is the standard of proof? So in criminal cases, it's a different standard, and in civil cases, the burden for past costs that somebody has paid for, maybe they've paid out of pocket for physiotherapy up until the date of trial or other things. The standard of proof for that stuff is was it more likely than not needed? So did this person need to, have $5,000 of whatever it is, physiotherapy? It's not this high standard of like, you have to be 100% sure or beyond a shadow of a doubt. It's just, is it more likely than not when you weigh the evidence that the person needed those things? And then moving into the future, and this is something that we try to point out when we're asking people like Lesha to prepare reports, and when we're asking doctors to weigh in on, a need for future surgery and things like that. The standard it's a little lower. So there's a case from 1977 from the Ontario Court of Appeal, or the Court of Appeal for Ontario, sorry, it's still good law. It's still the leading case in terms of this future stuff. And basically what the court said is that it isn't, you don't show that something is possibly needed, like maybe, who knows, it'll be needed in the future. It has to be more like probable. But they don't expect you to prove the future, so you can't prove that something is ever going to happen in the future, but they do want to have medical and other evidence to show that it is probable to arise as a need. And the court suggested that what needs to happen is the jury or the judge needs to be able to evaluate the chance of the need or the event arising, and that rather than use language like possible, we should use language such as, is there a risk that this will happen? Is there a danger that this will happen? Is there a likelihood that this will happen? Or that the need will arise? And the language that they sort of settled on towards the end of the case is that there is a real and substantial chance supported by evidence. So that's the test that we look at. And in that case, the chance that something was going to happen was a future surgery, and the orthopedic surgeon had given an opinion that it was 25 to 50% likelihood in the future, and the Court of Appeal believed that that met the test of real substantial possibility, real and substantial chance that had been supported by the medical evidence that this person was going to need this surgery and therefore needed these other types of care as a result. So that's what we look at, and we try to point that out when we're asking for reports, and we try to use a deadline after which we say, this is the test, and up until, the date of trial that we have planned, then we need it to be more likely than not. So I'm sure that's something that you guys have both heard before, but I just point that out for our listeners. So that's really everything that I wanted to cover off today, and I really thank both of you. Is there anything else that you want to add that you think would be helpful for the listeners?
Well, I think we've covered it pretty well. Thank you.
Okay.
Agreed.
Great. Okay, well, as I said, thank you so much for taking time out of your busy days to help me with this recording, and I appreciate it very much, and I will hopefully be speaking with you at some point in the future.
Yeah.
Thank you.
Thanks.